Subscribe to our channel and press the bell icon so that you never miss any video lesson from Rao's IAS Study Circle. Join the official Telegram channel of Rao's IAS Study Circle to stay updated and get all the materials on the Telegram. The link to the channel can be found in the description box. Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading from a UPSC Civil Services examination perspective. Today let us take up the important news appearing in New Delhi edition of the Hindu newspaper dated 15th September 2021. The news to be discussed has been displayed on your screen and timestamping for the same has been provided in the description box below. So on this note, let's start our today's discussion from our UPSC Prelims and Mains perspective. Now, our first article for discussion appears on page number 6. It says, "Behind the Great Indian Internet Shutdown, the tag of the world's internet shutdown capital stems from a lack of compliance with Supreme Court guidelines." So, this article talks about two important things. Number one, increasing cases of internet shutdowns in India, and this also impacts the democratic rights of citizens. And number two, lack of compliance of Supreme Court judgment or guidelines. That is, there is no steps taken by the central or state government to ensure compliance of Supreme Court and High Court guidelines. So primarily this article talks about the important Supreme Court judgment of Anuradha Bhasin versus Union of India, where Supreme Court laid down proper guidelines regarding internet shutdown. However, it has been witnessed in various instances with respect to various state governments also that the Supreme Court judgment of Anuradha Bhasin is not being complied. Another issue highlighted in this article is the fact that it has been witnessed in most cases that with respect to internet shutdown orders, these orders are not published, and this allows the respective government to take arbitrary action at times, which also leads to or which also results in non-publication of internet suspension orders. So on this regard, let us understand the important highlights of this article with respect to some of the key features which was pronounced in the Anuradha Bhasin judgment by Supreme Court of India, and also certain concerns which has been highlighted in this article, especially with respect to non-compliance of orders of Supreme Court judgment. Now this article becomes important mainly from your mains perspective and becomes a part of GS paper 3 under security. As you can see, it provides for challenges to internal security through communication networks, role of media and social networking sites in internal security challenges, and also basics of cybersecurity. Next, it also becomes important under GS paper 2 regarding important aspects of governance, transparency and accountability, and also role of civil services in a democracy. So first of all, let us go through the important highlights of Anuradha Bhasin judgment, and then we shall go through some of the concerns which has been highlighted in this article. Now this judgment very clearly held that use of internet as a medium to propagate freedom of speech and expression and freedom of trade and commerce is a constitutionally protected right and is also a part of fundamental right. So use of internet as a medium to ensure freedom of speech and expression as provided under Article 19(1)(a), and also use of internet as a medium to ensure freedom of trade and commerce as provided under Article 19(1)(g) is a constitutionally protected right under Part 3 of the Indian Constitution. So this becomes the first important highlight of this particular judgment. Now the second most important highlight of this judgment was that the Supreme Court held that the temporary suspension of telecom services public emergency or public services rules 2017 are the only procedure to be followed to suspend internet services. Now this means that the government can only suspend internet services under this particular telecom suspension rules of 2017. Further, the Supreme Court also highlighted that the use of this particular rules can only be used in cases or in grounds of public emergency, that is when there is a case of public emergency and the government feels that it is necessary to suspend internet to avoid any law and order situation or in order to ensure public safety. So only in both these conditions can the government use telecom suspension rules of 2017 to suspend internet. However, this rule cannot be used to suspend internet indefinitely. So this can be said to be another very important guideline issued by the Supreme Court with respect to internet suspension. Further, the Supreme Court highlighted that as per the Telecom Suspensions Rule of 2017, the direction for internet suspension must be given by, with respect to Union Government, by the Secretary to Ministry of Home Affairs, and with respect to State Government by Secretary to the State Government in charge of Home Department, or any other officer who has been authorized by Secretary to the Ministry of Home Affairs with respect to Union Government, and Secretary to the State Government in charge of Home Department with respect to State Government. Now the provision also says that in case of unavoidable circumstances, that is where obtaining this prior direction of Secretary of Ministry of Home Affairs is not feasible, then by any officer not below the rank of a Joint Secretary to the Government of India. So these are the only competent officers who can issue internet suspension orders as per the rules of 2017, and the Supreme Court said that these rules must be complied with. Further, as per the rules, it also says that once an order has been published to suspend internet, then such an order must be forwarded to the review committee. Now, in this regard, the rule says that the central government and the state government shall constitute a review committee. So, for the central government, the review committee shall be chaired by the cabinet secretary, and for the state government, the review committee shall be chaired by the chief secretary. Other members of review committee for central government includes Secretary to the Government of India in charge of legal affairs as member, and Secretary to the Department of Telecommunication also as member. And with respect to state government, apart from the chief secretary who is the chairman, Secretary of Law or legal in charge or legal affairs as member, and Secretary to the state government other than the Home Secretary also as member. Now the function of this review committee under the Telecom suspension rule of 2017 shall be to record the findings as to why internet suspension order was issued. That is, whether there was any reasonable grounds of public emergency or to ensure public safety. And this committee shall record its finding. And here the Supreme Court highlighted the importance of compliance of these rules provided under the Telecom suspension rule of 2017. Moving further, another very important highlight of the Supreme Court judgment was that internet suspension cannot be done for an indefinite period. And because of the Supreme Court judgment, the government amended the Telecom suspension rules in 2020. And according to this amendment, internet cannot be suspended for more than 15 days. So this can be said to be a welcome change after the Supreme Court judgment of Anuradha, Bhasin. Now another important point highlighted in this judgment was that the government must publish the internet suspension orders. Now this is one point of contention which has been raised in this article, and various concerns have also been raised, as it has been noticed that some of the state governments are not publishing the internet suspension orders. And lastly, the Supreme Court also held that these government orders to suspend internet are subject to judicial review. So these can be said to be some of the important highlights of Anuradha Bhasin judgment, and also some of the important guidelines provided under the Telecom suspension rules of 2017, which must be complied by the central or state government who intends to suspend internet for public emergency or to ensure public safety. So after understanding the important highlights of this particular judgment, let us now go through some of the concerns which has been highlighted in this article, especially regarding non-publication of internet suspension orders. Now the first concern highlighted with respect to non-compliance of the Supreme Court judgment is a direct impact on fundamental rights, as suspension of internet impacts both Article 19(1)A and also 19(1)G. Now in this digital age, use of internet has been widespread, and internet is being used with respect to dissemination of information, providing education to children, providing healthcare, also for entertainment purposes, livelihood aspects, and also it provides a sort of a platform for interaction among different members of the society. So regarding these widespread use of internet, suspension of internet definitely impacts a sizable population. Now in one of the survey, it has been highlighted that most number of Indians use mobile as a source for their internet use. So suspension of internet not only impacts this aspect of information, but also impacts the aspect of livelihood. So the first concern highlighted in this article is regarding impact on fundamental right, especially when Anuradha Bhasin judgment is not complied with in letter and spirit. The next concern we have already mentioned about, suspension orders not published by respective state governments. Now the problem here is that non-publication of these internet suspension orders leads to arbitrary action by respective governments, and this also leads to non-compliance of Supreme Court judgment, especially with respect to Anuradha Bhasin. Now, it has been also noticed in the past that various police stations have reported complaints even on Section 66A of Information Technology Act, which has been declared unconstitutional by the Supreme Court in the famous Shreya Singhal judgment. However, various police stations have stated that they are very much unaware about this particular Supreme Court judgment. Similarly, RTI filed by Meghalaya government also stated something very similar. The Meghalaya government stated that it is not at all aware about the guidelines issued by Supreme Court in Anuradha Bhasin judgment. So this becomes another point of concern with respect to lack of awareness about these important Supreme Court judgments, and this lack of awareness also leads to non-compliance of these important guidelines issued by the Supreme Court. Further, the article also says that non-publication of these internet suspension orders also helps the government to avoid judicial scrutiny. Now, this is because even if a person files a PIL or a petition in the High Court or Supreme Court, then the maximum what the High Court or Supreme Court can do is to ask for the order from the government regarding internet suspension. And this overall delays the entire process, and in this process of delay, this arbitrary action of the state government fulfill its purpose. So overall, non-publication of internet suspension orders not only allows the respective government to take arbitrary action, but also helps the government to avoid judicial scrutiny. And lastly, the article also mentions about impact on Indian economy with respect to increased internet suspension orders across different parts of the country. So considering all these concerns, the question arises as to what needs to be done. And in this regard, the article suggests that there must be statutory recognition to Supreme Court judgments, which means that the government either issues respective rules with respect to complying the Supreme Court judgments or provides certain legislation to ensure compliance of these important Supreme Court judgments, or to amend previous legislations in order to ensure compliance of Supreme Court guidelines or Supreme Court judgments. And this, as the statutory recognition by the central government, will also ensure compliance by central and state governments, and it will also increase awareness about the Supreme Court guidelines. So these are some of the important things which can be done in order to ensure that India is not called the internet shutdown capital of the world. Thus, this article becomes important mainly from the perspective of GS paper 3 and also GS paper 2. So with respect to this article, questions can be asked in your mains examination regarding the impact of internet shutdown and also the aspect of accountability on behalf of the government. So after discussing this article, let's take up our next article. The next news to be taken up appears on page number 10. Now this news says that finally Jammu and Kashmir tribal population to get their due, and this due is with respect to implementation of Forest Right Act. It says that implementation of Forest Right Act is expected to elevate socio-economic status of the tribes of Jammu and Kashmir. And these tribes are mainly Gujars and Bakarwals. Now previously there have been instances of eviction of Gujar and Bakarwals from their forest lands. And this was possible because the Forest Rights Act or the Scheduled Tribes and other traditional forest dwellers recognition of Forest Right Act 2006 was not implemented in the erstwhile state of Jammu and Kashmir. But now the government has decided to implement this particular act in the Union Territory of Jammu and Kashmir. So this topic becomes important from our examination perspective, and questions can be asked in our prelims and mains examination with respect to GS paper 2 and also GS paper 3. Now this tribal population of Jammu and Kashmir, namely Gujars, Bakarwals and other tribal populations, depend mainly on these forests for their livelihood and shelter. So continuous threat for their eviction impacted their forest rights. So as already stated in this article, it says that implementation of this act will elevate the socio-economic status of a sizable section of the population of tribals and nomadic communities, including Gujar Bakarwals and Gaddi Sippis in the Union Territory of Jammu and Kashmir. So with respect to this news, let us first of all understand the aims and objectives of the Forest Rights Act of 2006. Now as per this act, it says that this act aims to recognize and vest the forest rights and occupation in forest land in forest dwelling scheduled tribes and other traditional forest dwellers who have been residing in these forests for generations but whose rights could not be recorded. So it basically addresses the historical injustice done to the people who are dwelling in forest, that is traditional forest dwellers and scheduled tribes, with respect to recognizing and vesting of forest rights and occupation in forest land. And in the process, it also provides for recording of their forest rights and also to provide for a framework in order to record their forest rights. Further, this act also says that it recognizes the rights of the forest dwelling scheduled tribes and other traditional forest dwellers with respect to responsibilities and authority for sustainable use, conservation of biodiversity and maintenance of ecological balance, strengthening the conservation regime of the forest, and also ensuring livelihood and food security of forest dwelling scheduled tribes and other traditional forest dwellers. So overall, we can say that this act recognizes the rights of scheduled tribes living in forest areas and other traditional forest dwellers with respect to conservation of biodiversity, maintenance of ecological balance, ensuring livelihood and food security for them, and overall, this act aims to address the historical injustice done with these tribal communities with respect to non-recognition and non-preservation of their forest rights prior to independence. And since this particular act is now being implemented to Jammu and Kashmir, effectively it will recognize the rights of scheduled tribes and other traditional forest dwellers of Jammu and Kashmir, and overall it will help in addressing their need with respect to food, water, livelihood, and also reclaiming of rights on forest land. So in this regard, rights guaranteed under Forest Rights Act 2006 includes title rights, use rights, relief and development rights, and also forest management rights. Now regarding title rights, the forest dwellers have right to ownership of certain areas of land. Now with respect to use rights, the forest dwellers have right to minor forest produce, including ownership of minor forest produce, grazing areas, and also pastoralist routes. Regarding relief and development, this act provides for rehabilitation in case of illegal eviction or forced displacement, and also provides for basic amenities subject to restrictions for forest protection. And the act also provides for forest management rights to protect forest and wildlife. So these are some of the important right guarantees to scheduled tribes and other traditional forest dwellers under the Forest Rights Act of 2006. Now let's go through section 6 of Forest Rights Act. Now you must be wondering that why I have taken this particular provision. So it says that authorities to vest forest rights in various dwelling scheduled tribes and other traditional forest dwellers and procedure for these purposes. Now let's take up this particular question asked by UPSC in 2013. It says that under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006, who shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights or both? Options provided were A. State Forest Department, B. District Collector or Deputy Commissioner, C. Tehsildar, Block Development Officer or Mandal Revenue Officer, and D. Gram Sabha. So here it is the Gram Sabha which becomes the authority to initiate the process with respect to determination of nature and extent of individual and community forest rights. And in this regard, Gram Sabha will pass a resolution to this effect, and this resolution passed by Gram Sabha will then be passed to the subdivisional level committee, and from subdivisional level committee it will then be passed to the district level committee. Further, this provision also provides for procedure for appeal. Now here, any person aggrieved by the resolution of Gram Sabha may prefer a petition to the subdivisional level committee. So suppose when Gram Sabha passes a resolution with respect to determination of nature and extent of individual or community rights, and such individual or community is aggrieved by this resolution passed by Gram Sabha or decision of Gram Sabha, then such individual or community may appeal to subdivisional level committee. Now the subdivisional level committee may either agree with Gram Sabha or do not agree with Gram Sabha. So in either case, this subdivisional level committee will pass another resolution. Again, if the person concerned, that is individual or community, is again aggrieved by the subdivisional level committee, then they may also prefer an appeal to the district level committee. So this is the mechanism provided under this act with respect to procedure for appeal. So after understanding these provisions, let us again go back to the question asked by UPSC in 2013. So this question says that under this Forest Right Act, who shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights or both? And in this regard, it is initiated by Gram Sabha. So clearly, questions have been asked by UPSC from this particular provision, that is section 6 of Forest Right Act, especially regarding authorities to vest forest rights in forest dwelling scheduled tribes and other traditional forest dwellers, and also regarding procedure for appeal. Thus this particular act becomes important both from our prelims and mains perspective, as it recognizes and vests the forest rights and occupation in forest land in forest dwelling scheduled tribes and other traditional forest dwellers. So now the tribal communities and other traditional forest dwellers of Jammu and Kashmir will have the protection of Forest Right Acts in case they are threatened for eviction from their forest area or from their forest land. Thus this article becomes important both from our prelims and mains perspective, as we have seen questions have been asked by UPSC in the past. So with this, let's take up our next article for discussion. Now the next article to be taken up appears on page number 7. It says partners in the Indo-Pacific. The 2+2 dialogue between India and Australia will provide substance to an already meaningful partnership. Now both India and Australia faces common security challenges in the Indo-Pacific, as they both believe in free, open, inclusive and rule-based Indo-Pacific region. And this idea also includes stability and freedom of navigation for all nations in the region. Further, both these countries, that is India and Australia, also believes in economic integration of Indo-Pacific, and both prefer rule-based international order. They believe in inclusive economic integration in the Indo-Pacific region and accordingly face challenges from a belligerent China. So in both these perspectives with respect to common security challenges and economic integration of Indo-Pacific, both India and Australia sees China as the common problem. Now it is with respect to this common problem, Prime Minister of India and Australian Prime Minister elevated India and Australia's bilateral strategic partnership to a comprehensive strategic partnership in June 2020. And in some way, the personal connection between the two Prime Ministers also helped in providing the political framework which was needed to solidify and strengthen this partnership between India and Australia. So, we can say that as of now, there is a growing convergence of views on geostrategic and geoeconomic issues backed by a robust people-to-people connection. That is, Australia have a strong Indian diaspora of almost 1 lakh population. So it is in this regard, both India and Australia have ventured into the Quad, which comprises of India, Australia, United States of America and also Japan. So in this article, let us go through some of the important highlights of India-Australia relationship along with certain challenges and glitches in their bilateral relations. So from our examination perspective, this topic becomes important under GS paper 2, especially with respect to international relation. And questions can be asked with respect to bilateral relation between India and Australia, bilateral or global groupings with respect to Quad, and impact on India's interest, and also effect of policies and politics of developed and developing countries on India's interest and Indian diaspora. So it is in this regard, let us go through the important highlights of India-Australia bilateral relationship. Now as we have discussed, two important aspects of this relationship is facing common security challenges in the Indo-Pacific region and aim for integration of Indo-Pacific with respect to economy. So on the perspective of economy, the significance of India-Australia bilateral relationship on the perspective of economy is that Australia is an important trade partner of India, having bilateral trade around $25 billion. And in this regard, Australia can be India's key partner with respect to Make in India program. as Indian companies have ample amount of investment opportunities in mining and energy industry of Australia. And on the reciprocal side, India's infrastructure sector under the National Investment and Infrastructure Fund can offer investment opportunities to Australian investment funds like pension funds. So in the area of economy, there have been certain significant outcomes of India-Australia relationship. It includes signing of double taxation avoidance agreement to avoid taxing of offshore income of Indian companies, jointly deciding to explore the possibility of launching the Indian Rupee card in Australia. Now, with respect to maritime relationship, both India and Australia share common vision of free, open, inclusive and rule-based Indo-Pacific, as we have already discussed. And India and Australia also have common concerns regarding the strategic, security and environmental challenges in the Indo-Pacific maritime domain. And both these countries view China as a common concern. Now, regarding the outcome on maritime relationship, Australia have welcomed and granted rupees 8 crore to India's Indo-Pacific Ocean Initiative, whereas Australian Navy became an active participant of Indian Ocean Naval Symposium, which has been started by India. Now, with respect to defense, we can say that Australia is one of the key defense partners of India. And in this regard, both Australia and India have signed Mutual Logistics Service Agreement, and they have also signed the White Shipping Agreement. Further, both India and Australia also conduct bilateral maritime exercise, namely AUS Index, once in every 2 years, and Australia also participated in Malabar naval exercise along with United States and Japan. Now, regarding Mutual Logistics Supports Agreement, it facilitates reciprocal access to military logistic facilities, that is both from India and Australia, and also improve interoperability between the security forces of the two countries. Now, such kind of exercise and support agreements are useful during bilateral naval exercises along with humanitarian and also disaster relief and rescue operations. Whereas White Shipping Agreement refers to exchange of relevant advance information on the identity and movement of commercial non-military merchant vessels. Now, this not only provides information on the sea, but also makes the Indian government aware about the identity of certain vessels which may pose any threat to India rising from the sea. And such information can then be directly transferred to the coastal and offshore security of both countries in India, namely the Indian Coast Guard. So, exchange of such information on non-military merchant vessels also helps us in knowing the potential threat which can be dangerous to either countries. Now, with respect to energy, we know that Australia is rich in coal, uranium and also natural gas reserves, and accordingly can play a key role in India's energy security. Now, regarding the outcome with respect to energy, both India and Australia have signed a civil nuclear cooperation agreement. Australia has openly supported India's membership in NSG, that is Nuclear Suppliers Group, even though India is a non-signatory of NPT, that is Nuclear Non-Proliferation Treaty. Now, on strategic and multilateral cooperation, both India and Australia are part of Quad grouping, which also includes Australia and United States. And both countries believes in the idea of multilateralism. And in this regard, Australia has openly favored UNSC reforms and India's candidature for permanent membership to United Nations Security Council. And with respect to diaspora, there is a presence of strong Indian diaspora in Australia. And India's diaspora is also one of the largest sources of skilled migrants in Australia. Further, India is the second largest source of international students in Australia. So clearly there is a strong Indian diaspora in Australia. And based on this, both the countries has designed the Migration and Mobility Partnership Arrangement to prevent illegal migration, human trafficking and also to facilitate mobility of students, academics and researchers, and also migration for professional and to facilitate migration for economic reason. Now, despite these areas of convergence, there are also certain areas of divergence between India and Australia. And these area of divergence is with respect to the dichotomous Australian foreign policy, as there is some sort of non-alignment between Australia's foreign policy and economic policy. Now, this non alignment arises from the fact that even though Australia has been actively engaging with India, United States, and Japan as part of Quad grouping, still Australia's economy largely depends on China. So, there is a mismatch between expectation and reality. Another ground for concern is the Comprehensive Economic Cooperation Agreement between India and Australia has yet not been materialized, even though the negotiations started way back in 2011. So, this can be said to be so far as a hindrance to bilateral trade between the two countries, as both India and Australia have not yet been able to sign or materialize the Comprehensive Economic Cooperation Agreement. Now, another reason of conflict is regarding RCEP. So it says that India's withdrawal from RCEP was objection from farmer organizations and dairy cooperatives, and this was because of flooding of cheaper agricultural and dairy products not only from China but also from Australia. So Australia also poses a significant threat with respect to cheaper agricultural and dairy products, as such cheaper agricultural and dairy products can flood Indian market, thereby hampering India's farmers' economic interest. So these can be said to be some of the glitches with respect to bilateral relation between India and Australia. However, the camaraderie between the Prime Minister of India and Australia has not only elevated bilateral strategic partnership to a comprehensive strategic partnership in June 2020, but has also strengthened India and Australia's bilateral relationship. So it is in this regard we can conclude by saying that hopefully this comprehensive strategic partnership between India and Australia will remove the hindrance or challenges which will ultimately help in improving the bilateral relation between India and Australia across different fields which we just now discussed. This question in your mains examination can be asked with respect to India-Australia bilateral relationship, increasing cases of opportunities, and also certain challenges with respect to the bilateral relationship. So, with the discussion of this article, let's take up our next article. Now, let's take up our last article for discussion appearing on page number 11. It says India and Singapore to link fast payment systems. And this link of fast payment systems between UPI and PayNow will aid instant fund transfer. So, RBI, that is Reserve Bank of India, and Monetary Authority of Singapore have announced a project to link their respective fast payment systems, namely Unified Payment Interface for India and PayNow for Singapore, for instant and low cost fund transfers on a reciprocal basis between the two countries, namely India and Singapore. Now, this will facilitate trade, travel, and also remittance flow between the two countries, namely India and Singapore. Now, further, according to the Reserve Bank of India, this is a significant milestone, especially with respect to development of infrastructure for cross-border payments, and in this regard with respect to India and Singapore. It further says that this project closely aligns with G20's financial inclusion priorities, that is, driving faster, cheaper, and more transparent cross-border payments. So this particular project to link fast payment systems with respect to UPI and PayNow is also in line or in sync with G20's financial inclusion priorities. Further, this initiative is also in line with RBI's vision of reviewing corridors and charges for inbound cross-border remittances, which has been outlined in RBI's Payment Systems Vision document of 2019-21. So considering all these important facts, this particular news with respect to linking of fast payment system between India and Singapore becomes important primarily from our prelims perspective, and questions can be expected in the section of Indian economy. Now, with respect to India's UPI, it is India's mobile-based fast payment system which facilitates or allows customers to make round-the-clock payments instantly using a virtual payment address. And this virtual payment address is created by the customer. Further, UPI supports both person-to-person and person-to-merchant payments, as it also enables the user to send or receive money. Now, similarly, Singapore's PayNow is also a fast payment system which enables peer-to-peer funds transfer service available to retail customers through participating banks and also non-banking financial institutions which are present in Singapore. On similar lines of UPI, the PayNow of Singapore allows or enables users to send and receive instant funds from one bank or e-wallet account to another in Singapore by just using their mobile number. Thus, this news with respect to linking of fast payment system between UPI and PayNow, that is UPI of India and PayNow of Singapore, becomes important primarily from our prelims perspective, and questions can be expected on any of these following aspects as well, as this project also closely aligns with G20's financial inclusion priorities, and it is also in line with RBI's vision of reviewing corridors and charges for inbound cross-border remittances. So with this discussion, let's take our question for the day. Now, based on our discussion, this becomes your practice question for the day. It says, consider the following statements with respect to the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. Options are: first, there is no mechanism for appeal against decisions of Gram Sabha. Second, the Act ensures right of ownership, access to collect, use and dispose of minor forest produce which has been traditionally collected within or outside village boundaries. So the question is, which of the statements given above are correct? Options are A, 1 only, B, 2 only, C, both 1 and 2, and D, neither 1 nor 2. Now coming to the answer of yesterday, the question was, consider the following statements related to Wholesale Price Index, that is WPI, and Consumer Price Index, which is CPI. So the first statement says both WPI and CPI are published by the National Statistical Office. No, this statement is incorrect, as WPI is published by Office of Economic Advisor under Ministry of Commerce and Industry. Second, the increase in the food prices would have a higher impact on CPI as compared to WPI. Yes, this statement is correct because the CPI gives much higher weightage to food and beverages category. So the second statement becomes correct. So the question was, which of the statements given above are correct? So here the correct answer becomes B, that is 2 only. So with this we come to an end to today's discussion. Thank you for watching DNS.